I've been asked to go first as a bit of an intro. I'm not sure exactly how the various talks are going to fit together, but I've been asked to comment a bit on law and where does the law fit into issues around fish and fish welfare more generally. I'm just going to, because it could, it's a topic that can encompass so many issues. I'm focusing particularly on commercial use, so aquaculture and commercial wild capture as the particular areas of interest. And hopefully I'll end up with a positive comment at the end, though I must say that I've become a bit cynical about what law can do about a lot of animal welfare issues, not to mention fish. So we'll see if I can be a little bit more positive by the end. So what I'd like to do is try to catch this as I'm the first person as well to speak as an opportunity, because I don't think that the issue of fish and fish welfare and the use of fish has really been given much attention in Australia, particularly. And I think we have a great chance today to try to pull together a number of different perspectives together. And maybe this is just the starting point of further conversations and thinking about the issues and figuring out what are some ways forward to take into account the various interests that are raised in the use of fish in different contexts, and we're thinking particularly of food here. But when I was thinking of the different an opportunity, different voices perhaps that would be taken into account. Sorry, I keep looking at the screen up there. I shouldn't do that. Community concerns. I think it's quite a new area for community, the public, so to speak, to be thinking about fish in a welfare context. But there's certainly been an increased awareness of it being something to think about. Like maybe people don't know where they stand, but it's at least something worth considering, and whether fish should be given at least some consideration in making decisions about how to use them or what have you. Of course, the area of welfare science or behavioral science with respect to fish seems to be, from what little I can tell, an expanding field of research. When I was doing my earlier paper, trying to find scientific papers, there were plenty out there, but they tended to focus more on issues specific to production. So focusing on stocking densities or slaughter methods or what have you, whereas I think there's been an expansion beyond that to look at lots of different aspects of fish cognition and behavior and welfare and science more generally. So there's a lot to be brought in there. And then, of course, the growth industries. I mean, increasingly, the world population is relying on fish for food, and that's probably only going to increase. Particularly aquaculture seems to have really grown substantially, and Australia is well placed to take advantage of certain sort of a naturally cleaner environment perhaps, and can take advantage and sort of leverage off that in the area of aquaculture. So I think there's advantages to industry as well in being able to market sort of this green, clean, welfare-friendly product that can take into account various interests and concerns. So hopefully there'll be more opportunities beyond today, but to get some different views about where people are coming from and what we might be able to come up with as a way forward with respect to some of the welfare questions with respect to fish. So hopefully it'll be constructive. But with respect to the law, so what potential role does the law have to play? So my background is largely tax law, but also animal welfare law. And so when I was thinking about this topic, well, what can the law actually do? It seems to me that there's two different possible or areas or ways that the law could have something to say about fish welfare, potentially. So these are things to consider. What would be actually meaningful? One is the role of animal welfare laws to protect animals from cruelty. And so I'll talk a little bit about that first. Bearing in mind that animal welfare laws are, because they're criminal laws, they are designed to identify particularly egregious acts, to label them as criminal activity. So I think there's more than, that's one thing, but there's also a more general role potentially for the law to play in enhancing or ensuring that whatever we define as a good welfare outcome, whatever that is, can actually be achieved and can be monitored. appreciating, though, that the regulation of these industries, as I've just mentioned a couple, there's a myriad of different things that need to be taken into account. So a lot of the concern around using fish for food has come from the environmental perspective, sustainability, etc. There's food safety issues that are very important, disease control becomes important, and worker safety as well. So a lot of things need to be taken into account in this balancing of what's a good welfare outcome and what's achievable. And also there's the perennial concern that we have in the animal welfare context that a lot of these issues are the concern of the states and territories. So whenever we try to develop any new laws with respect to the use of animals, there is a desire for consistency, though it seems to be rather elusive through our best efforts. So the first issue is, thinking about the animal welfare law context. Now, I'm just going to highlight a couple of points around animal welfare law, animal protection law, because I'm not sure to what extent the audience might have looked at what these laws actually do. But each state and territory has their own piece of legislation that's directed towards the protection of animals. And so the New South Wales Act is mentioned there. So the concern, as I've tried to highlight there, is with respect to identifying a particular act or omission as the criminal act, the offense, the act that constitutes an offense. And it's identifying an individual person with respect to usually an individual animal or a group of animals. So it's a very specific, it needs to be specifically identified to be able to operate. Because of that, because it is such a specific thing and because it is a criminal law, I think it has, at this stage, probably only a limited role, but still an important one. I still think there is an important one, an important role in the fish context. So the basic offenses, I've just listed them based on the POCTA sections. So the traditional offense, the act of cruelty. Now, this language that we see here, which is very similar across the various states, really hasn't changed a whole lot since the very first animal welfare laws back in the early 19th century, really. And so we have these standards of unreasonably, unnecessarily, or unjustifiably causing various harms to an animal. And so it's this reasonableness standard, so it's a balancing of interest, and this is the way the law does work. And so we need to be able to get that definition to work, what is an act of cruelty, we need to measure the harm to the animal as against the justification, if there is one, of the person inflicting that harm. So justification could be, it could be any number of interests. It could be a person is using an animal for the conduct of their business, their livelihood. Often when there is food production involved, things are justified under the law that might not be justified outside of a food production context. But the difficulty with applying these sorts of general standards, which is the best that we have in the fish context, is that I think we're still at perhaps an early stage to be able to identify the degree of harm to the particular animal that is the subject of the consideration here. From what I can tell from the science of fish welfare, there are certain things identified as potentially harmful with respect to specific species of fish in particular contexts. And we can't, in applying these sorts of standards, we can't generalize. I mean, we're talking about, identifying a criminal offense, which is a pretty serious issue. So anthropomorphizing is not enough, right? We actually need evidence-based standards to be able to identify or to measure harm and compared to potential justifications. But it may be that these laws still have a role if there is no justification. So the concept of sort of wanton cruelty. So just, abusing an animal for the fun of it, where there is no actual weighing up of interest because there is no counteracting interest. So I still do think that there is a place for fish within that context because of that sort of outer limit that it does provide. The other major part of animal welfare laws are duty of care provisions, and I've described sort of basically what they do. But you can see, if I skip to the bottom here, that they're generally couched in the terms of terrestrial animals. So we're talking about providing adequate exercise. I don't think that makes much sense in a fish context, right? But that's the way the laws are written, because although most of them include fish within the definition of animal, the provisions once you get into the Act don't really reflect fish relevant issues. The first one, providing reasonable care to alleviate pain, of course, could potentially apply. The other thing is also that these only get triggered if you have a person in charge. So the obligations are only where the animal's under the care or control of an individual, and then that individual fails to meet their duty of care. So, of course, that's not going to apply in a wild capture context until there's actually contact with the fish. So I've sort of mentioned there. So it really is could potentially be relevant in an aquaculture context more than in a wild capture area. So the question, should fish receive protection from cruelty under these laws? Taking a quick look at what the laws say about who is an animal. So it can only apply, because we love definitions in the law, the animal welfare laws only apply to animals, and animals is defined. So it's always a defined term in every act. In most of the jurisdictions in Australia, fish are included in the list. So there's a general presumption of vertebrates being covered, excluding human beings, and fish being on that list. Whether that was really thought through at the time is another thing, but they are just generally included in the list. But there are some important exceptions. The Northern Territory only in limited circumstances, and South Australia and Western Australia, they're carved out. But then there's additional carve-outs or exclusions. So fishing activities, quite often the particular jurisdictions act will exclude anything, any action in the course of fishing activities, but there are certainly fish in other contexts that would stay within the purview of the law. But I still, so even if the excluded activities are regulated elsewhere, so for example, in Western Australia, there is a separate Fish Resources Management Act that includes within it the possibility for regulations to be enacted with respect to cruelty and animal welfare and health. And there's also the powers of fishery agents are extended to include those that animal welfare inspectors have under the Animal Welfare Act. So there is a consciousness of a need for fish welfare issues to be dealt with somewhere. They just are shifted over into the Fisheries Management Act rather than in the Animal Welfare Act in WA. But I still think that even if that does exist, there's still a role for the Animal Welfare Act to keep fish in there, to catch activities outside of those things regulated elsewhere, and also to potentially apply to those behaviors on the extreme, to have that stopgap for the Criminal Act to still potentially apply. So to have perhaps residual application as we stand now. But that's something that needs to be thought through. These are just some of my thoughts so far. So then the other potential role for the law is enhancing or ensuring welfare outcomes as might be determined. And this is where the best mechanism is really up for grabs, right? So I've started with there's voluntary codes of practice or guidelines. On the next slide, there have actually been efforts by industry to develop some guidelines, best practice guidelines, whether that's formalized into certification systems. A lot of animal production industries do operate certification systems. If their standards are considered adequate and they actually do the inspections, then that may be considered by the public to be sufficient, that we don't need the law to step in and do something in addition to that. The animal welfare legislation is one place, though I think it is difficult to fit these particular issues into a context of unreasonable, unjustifiable harm. And the fishery management laws perhaps are a way forward to include licensing conditions to meet certain criteria or guidelines as a possibility. But these are all different ways that one could potentially include or more formalize some sort of welfare objectives. In the terrestrial animal context, so in the land-based livestock arena, there's been ongoing difficulties for decades using standards and guidelines, and there is a new process that's been underway for a few years to rewrite the the codes of practice into standards and guidelines. And it's not for me to judge here today whether that's been successful or not, but it hasn't been adopted as consistently as was hoped. That was one of the purposes, was to have consistency, and at least we can't judge. I'm not going to judge whether it actually works, but it has faced some difficulties, and perhaps in the area of fish we could do better, right? So we have this model of land livestock that doesn't really work. So perhaps in the fish context there's more opportunity, because it is a new area, to perhaps start out on a more positive note. I think from a legal perspective, any standards or guidelines that are going to have any legal force need to be evidence-based. I think there is a danger of generalizing and anthropomorphizing. If you're going to have something that's enforceable, there needs to be something to back it up, to say, why is this important to this animal? But because the science is changing and evolving and growing all the time, there's an importance that they be dynamic, or living, in quotes, documents, to be able to be adjusted as new work is done and evidence is provided, that those can be adjusted. And sometimes formalizing codes and standards into a law fixes them in time. It makes it more difficult for them to adjust to new work. I know the codes of practice in the land-based livestock, they almost get written in stone. It's very hard to, redo them and shift them and amend them. Whereas I think in this area in particular, there needs to be a dynamic dialogue. I've just mentioned 3 areas where I have found from trolling through the internet, where already industry and government have been working to try to establish some guidelines, and I think that's really positive. I mean, whether you think they go far enough or they go too far is a different question, but at least there is work being done that perhaps can include a broader community to develop further. Even in the first one there, the Aquaculture Code of Conduct, it's very generalized, but it was very pleasing to see that of the 5 key objectives, humane treatment was one of them. Right? I think that's important to recognize that is being acknowledged, as, particularly in the aquaculture area, as an important concern. And there's some different things to look at there. The other thing is that I think that there needs to be sector and species specificity, right? So a particular standard that may be suitable, this is going to reveal my lack of knowledge, that might be suitable for salmon wouldn't necessarily be suitable for barramundi, right? I mean, they have very different needs. The concept of fish is an extremely broad one. We all have our own ideas about what even is a fish. And within sort of the fin fish area, or bony fish, there's a lot of variation in different needs, and stocking densities for one type of fish may be completely different for what another type of fish might prefer. So there needs to be that evidence-based specificity, I think, for it to be meaningful, because if it's too vague, then it's not going to be of much use. And if a vague standard is sought to be applied into areas that it's not suitable, that's not going to be particularly beneficial either. So just concluding, to hark back to the beginning, I'm still not sure what the law should be doing in this area, but I think that it may well have a role. I think in sort of having that basic protection within the Animal Welfare Acts is important, even if it's merely symbolic, to just say, yes, fish are worthy of some consideration and therefore deserve to be listed there. But the actual detail in working out more specifics of actually working with fish in a commercial context, I think there's plenty of opportunities for people to work together to try to develop some standards that could hopefully benefit the fish, hopefully benefit industry by having a product that they can hold out there. Like we see a lot of the labeling systems now, it can be a marketing strategy, and hopefully we can get the scientists who really know what they're talking about into the dialogue as well, so we can work out something meaningful and useful. I think it's an opportunity worth taking. So hopefully after today, people start thinking and we can have more discussions in the future.